Today, the Supreme Court heard the argument in my case, and it will decide whether the government can respect everyone's freedom to say what we believe.
Lori Smith is a Colorado-based designer of wedding websites who got crossways with the state's anti-discrimination law when she refused for religious reasons to work for same-sex weddings. Under that law, claims of free speech or religious belief are insufficient reason to refuse service.
We are very concerned that if our side loses in this case, the court would open up an exemption that would make possible all sorts of professions, photographers, people make cakes, others who write books, to say, I'm not going to sell to someone based on who they are. The court has never recognized that exception, and to do so would threaten the core of our civil rights laws.
When the Supreme Court legalized same-sex marriage with its Obergefell decision in 2015, many agreed with the judgment.
When all Americans are treated as equal, we are all more free.
But it is important to draw attention to the caveat of Justice Anthony Kennedy, who wrote the court's decision.
It must be emphasized,
said Justice Kennedy,
that religions and those who adhere to religious doctrines may continue to advocate with utmost sincere conviction that by divine precepts, same-sex marriage should not be condoned.
Presumably by advocate, Justice Kennedy did not mean merely carrying the thought inside one's head.
Our rights are not up for debate.
In the 7 years since Obergefell was decided, the American left has been on a mission to diminish both the legal and practical foundations of the Constitution's free speech rights. They argue that the nation's anti-discrimination laws should be recognized as the more important of the two constitutional rights, and that the Supreme Court in Lori Smith's case, 303 Creative versus Helenius, should affirm this new reality.
If 303 Creative prevails here, then any business that can be characterized as expressive, and that's a lot of businesses, could start putting up signs saying, no Jews served, no Christians served, no blacks served, no gays served.
The left's playbook is to equate a broad definition of hate speech with incitements to violence, which don't receive First Amendment protection. Increasingly, the self-righteous left has donned the halo of anti-discrimination laws to create a society that simply bans an array of opinions they don't like. That included Jack Phillips, a cake baker, also from Colorado, who refused to bake a cake on the same grounds as Miss Smith today.
Mr. Phillips did go through a re-education training program pursuant to Colorado law, did he not, Mr. Olson?
He went through a process that ensured he was familiar with...
It was a re-education program, right?
It was not a re-education program.
What do you call it?
It was a process to make sure he was familiar with Colorado law.
Someone might be excused for calling that a re-education
I strongly
program.
disagree, Justice Gorsuch.
Don't regulate, create!
No single word in our time more reflects the attempt to suppress public disagreement than misinformation. In recent days, we've had the Trump Twitter ban revelations.
It's earth-shattering information that should concern every American, regardless of which side of the aisle you're sitting on.
And confirmation that medical specialists were censored on Twitter for opposing settled science on COVID-19.
You have Twitter suppressing that discussion, they're suppressing science.
While a Supreme Court ruling in favor of Lori Smith's right to her religious beliefs may maintain a bright line for constitutionally protected free speech, that distinction is close to disappearing in the realm of socially acceptable speech. 2 weeks ago, when protests spread against COVID lockdowns in China, the government told tech companies to censor and restrict information about the protests. There is absolutely no equivalence on speech suppression today between communist China and the United States, but an uncomfortable resemblance is emerging.